Okay, there we go. I did put some links in the chat, but they'll be in the presentation as well. So thank you for inviting me, and or at least thank you for Bruce strongly suggesting that I should speak. I also appreciate everyone's flexibility. Last week I was without internet due to a local fire, so I'm excited to share my passion with you tonight and hope that this is valuable. I want to start by making sure that we are all on the same page about the terminology for advanced care planning. Then I'll explain what Hamilton has to do with advanced care planning. I'm an attorney, and so talking policy for a minute is something I feel I should include in every presentation. And finally, we'll science the heck out of ACP to the extent I can, and then I will share some resources just to help all of you overcome the avoidance of discussion, which is something that research says is one of the reasons that no one does advanced care planning. Definitely feel free to put questions in the chat or interrupt me as we go along. I will have an opportunity for questions in the middle and at the end. So in an ideal world, we have good long-term relationships with our primary care provider. They would know us well, and we would have time to have conversations during appointments about everything that we needed to. When we were diagnosed with a serious illness, they would remain our primary contact, and we'd all be on the same page about what we as the patient want. But we live in the real world, which means most of us don't have these relationships. The right side here shows the list of professionals that may be involved in your care if you become seriously ill, and this is not an extensive list. And this is why we need advanced care planning. Advanced care planning are the tools and resources to help people when they can't make or communicate decisions about their medical care. In advance, people can decide who speaks for them, have input onto those treatment decisions, and sometimes make those decisions themselves. Advanced care planning is fundamentally about your values. It's about what you care about and what makes a good quality of life for you. The ethical concept of autonomy or personal choice is vital in healthcare. Technically, the lack of consent is battery. So advanced care planning is a way for you to have input into your care plan when you can't participate real time. And it has value for end of life, but it's not limited to that. For example, if you have an accident, your advanced directive can come into play, but you may not be close to death. States make talking about advanced care planning a real pain because they all use different terminology. I'm using the list of states that Bruce provided for the people likely to be on this call, so you can see the different terminology in your state. There are other terms I did not include here. And I share this because I expect that you'll learn a lot today and you'll want to share with others and just appreciate the challenge that if they live in another state, they might not understand what you're talking about. For POLST alone, and I'll get to what POLST is, we have 15 different names for that document in the United States. So you can be talking about POLST in Oregon with me, but if you're from Missouri, you're going to be calling it TPOP. Those aren't even close. So it's important to know what it's called in your state and appreciate that somebody might be talking about the same thing, but have a completely different name for it. In this presentation, I'll be using the term POLST, advanced directive, and surrogate, and I'll define all of these shortly. And I just want to connect those terms to what I just introduced. We're going to start with the first two bullets. In some states, these might be separate documents, but in most states, they're combined together into an advanced directive. So an advanced directive is a legal document, and it serves two purposes. First is you're picking your surrogate, or the person that would speak for you when you can't speak or communicate for yourself. Second, it allows you to have input into your treatment when you can't communicate. So this is where you can list your goals, your values, your preferences, things that you care about. And that can be included then in the conversation between your surrogate and healthcare team in deciding on a care plan. If nothing else that you remember from today, please remember to make your healthcare provider happy and identify your surrogate. I even said please. More often than not, in an emergency, your healthcare provider won't know you at all. So it's really reassuring to see that you've identified who you want to speak for you, and it gives them a lot more confidence when they're talking to that individual. When you can't speak for yourself, this is a loss of capacity. So please take the time to figure out who you want speaking for you. It's a really big deal. And if you can communicate and make a decision, the healthcare team will be looking to you. The advanced directive and surrogate only comes into play when you can't speak for yourself. You want the person speaking for you, your surrogate, to be the kind of person that's not going to leave or let things go unless all of their questions have been answered, and they know that you are getting the treatments aligned with what you would have wanted. You can think about, this is the person who needs to stand in your shoes, who has the who can appreciate your values, who's going to get all the information needed to make a decision, who feels comfortable not letting the doctor leave the room until the questions are answered, and then who will advocate for you. When you're a surrogate, the healthcare team is really going to occasionally push their agenda or their thoughts, and you need somebody strong enough to say, that person, that I wouldn't want that, or the patient wouldn't want that. And picking your surrogate, things to think about, it doesn't need to be your spouse or firstborn child. I've seen a lot of people think this, and it isn't necessarily the right person. Not all spouses agree, and sometimes one person might just be too emotional to handle making these kinds of decisions in a crisis, or you don't want to put that burden on them. There are 7 states without a statute that says who has legal authority to make decisions for you, unless you're talking about a withdrawal of life support situation. So in those states, if you haven't done your advance directive, then the hospital or care facility ultimately gets to choose who they want to listen to in making decisions. So Oregon folks, this is you. If you don't have an advance directive legally, there's no one that can speak on your behalf unless we're talking about withdrawal of life support. So complete your advance directive. Have a backup, especially if you choose your spouse, unless you never travel with your spouse. And then finally, tell that person that you've chosen them. Give them some heads up and ideally some idea of your wishes. And you can do that just in your advance directive, or you can actually talk to them. Be nice and don't surprise them. Surrogate burden. There are actually a few research articles on this concept of surrogate burden, which is defined as stress, guilt over decisions that have been made, or doubt about decisions that they've made on behalf of the patient. The studies have found that 1/3 of surrogates have experienced a negative emotional burden as a result of making decisions for somebody else. And these can be substantial, they can last for months or even years. But the good news is that when the surrogate knows and has a general idea of what the patient would have wanted, what they can learn through an advance directive, then that burden decreases. And the more information you can give or share, the better off the surrogate is and the less burden that they will feel going forward. Okay, you've done your part and you've picked your surrogate. So the next part of the advance directive is talking about treatment decisions when you can't communicate. What do you care about? Unless you have a good advance directive template, the portion of this document may be minimal. For example, in Oregon, we have a statutorily defined advance directive. There's only one version of the advance directive that exists, and that is in ORS 127. The section that talks about treatment wishes is basically worthless because it's written at such a high health literacy level that most healthcare professionals are aware that patients don't understand what it means, and so they don't really trust it. It's medical terminology that usually only professionals use, and so that just doesn't have a lot of value. In other states, however, especially states with very broad open statutes about what can be considered an advance directive, it can have a lot of value. And at the end of this presentation, I'll share some resources, especially with what Oregonians can do to make their advance directive actually have value. As a note, Oregon is also looking at redoing this, the statute on advance directives. So why would your advance directive be ignored? Well, as I said, healthcare facilities and doctors might not trust that you truly understand the decisions you've made on your advance directive. And this is really about the science of cultivation theory. So we're going to take a quick deviation and talk about that. So cultivation theory has cropped up a lot in a few years. I think it's also referred to as the CSI effect. And what it means is that exposure to media, especially to television, substantially cultivates viewers' perceptions of reality over time. And those misperceptions can subsequently affect health communication, expectations, and outcome. So think about ER, Grey's Anatomy, House MD, really any medical reality TV show. And this study looked at the knowledge and perceptions of what viewers of those shows knew about things like cancer screenings, organ donation, CPR, and other medical procedures that are often done on these shows. In just looking at CPR, the study found that on TV, 75% of the patients on those shows who needed CPR were revived and actually were fairly normal afterwards. They didn't really have any long-term damage. And they didn't end up in a very tragic situation. The reality is that CPR is a very violent act. It can normally leads to time in the intensive care unit. It can lead to broken ribs and potentially long-term damage. So the reality, looking at some 2016 data, is that if you have a heart attack in a public place, successful survival is around 19%. At home, it's about 70%. In a nursing home, it's around 12%. And that's just revival. So then you go to the hospital and are treated there. It's actually an average of a 12% success to hospital discharge. If you have a heart attack in a hospital, you have a 25% chance of surviving to discharge. So you can appreciate that 75 is very different than 25% survival rate. And this, you can hopefully see how healthcare professionals might mistrust your understanding about these medical treatments. And this is also because advanced directives can be done on your own. You don't need to talk to a healthcare professional to complete them. So getting back to advanced directives, once you've completed it, give it to your doctor. This is a step a lot of people miss because it's just not talked about very often, and on the documents itself, there's no reminder for the most part. But it's really helpful to give it to your doctor. They can put it in your medical record, especially now that we have electronic records. It's easy for them to then share it. And if you feel comfortable, give a copy to your surrogate. The biggest problems with advanced directives, and research has showed this time and time again, is that they can't be found when they're needed. People recognize that this document is valuable, and it is, so they put it in a safe. Sometimes they lock it, or they put it in a drawer that's locked, or they just don't tell people where it is. But that means when it's needed, no one can find it. And that's obviously not helpful. All right, moving on to the next concept of POLST. POLST exists in almost all states, but again, we have 15 different names for it. So I pulled out the list I provided earlier on the right. So those are the terms that you guys might know. A POLST form is a medical order. So an advanced directive is a legal document, POLST is a medical order, and it's divided into multiple sections. An example is on the left. Section A, all of them have these kinds of sections. So section A is about cardiopulmonary resuscitation, or CPR. And it's basically asking whether or not you want to be resuscitated. So if you aren't breathing, you don't have a pulse, you've died. And this tells emergency personnel if they should attempt to bring you back to life or if they should allow a natural death. Section B talks about the next step. So if CPR isn't the issue, but you still have a medical emergency, what's next? Full treatment means you want to go to the hospital, you're fine going to the intensive care unit, basically give me everything you've got. Selective treatment means you're okay going to the hospital, but you really don't want to be in the intensive care unit. And comfort-focused treatment means keep me where I am, make me comfortable. So this tells EMS basically whether or not they should transport you to the hospital. I usually go a lot more in depth on POLST forms, but this is kind of an overview, so I'm just gonna hit through this chart. But if you have questions, let me know. As I mentioned, POLST is a medical order as opposed to advanced directive being a legal document. All adults should have an advanced directive. If anything, at least just to say who your surrogate is. You don't even need to fill out the rest of it. The surrogate is really the most important part. A POLST form is for those people who are seriously ill or frail. The surprise question is for professionals. So what we train healthcare professionals is, if you wouldn't be surprised if your patient died within the next year or two, a POLST would be appropriate to offer to them. And this is because with a POLST form, you're talking about medical orders. So you need to have a very specific conversation about what those orders are. For example, if you have a chronic heart condition, you would have a conversation knowing that the most likely emergency is going to be a heart attack. And then you would talk about what does it mean for that person what are the odds of them actually surviving CPR? What does it mean for them to be in the ICU? What does that mean long-term given that medical condition and anything else that's going on? So it's a very detailed conversation. You don't have that information generally when you're talking about advanced directives because you're talking about a future unknown issue. So all you can really say is, this is what makes life good for me. And these are maybe treatments I care never to have or that I would be okay having. So they're very different audiences. Advanced directives, as I mentioned earlier, you can do it yourself. States have different rules about who may need to sign it, witnesses or a notary, or something like that. But for the most part, you don't need attorneys for them. A POLST form in every state is a medical order, so you should never be asked to complete it. It's something that a healthcare professional should do, and they have to sign it in order for it to be valid. Your advanced directive appoints a surrogate. Your POLST form does not. And the medical order piece is big here because EMS, emergency personnel, first responders, they're called a lot of different things. Of course, we have to keep our terminology varied among the states, but it's the people that show up when you have an emergency. EMS can't follow an advanced directive. It's not a medical order, and it's not ordering any treatments. It's just giving a general idea of what the patient would want. A POLST form is a medical order signed by a professional. So EMS, they're following that order. Again, do they provide CPR? Do they take you to the hospital? Pretty specific. And there's one more advanced care plan, technically, which is do nothing. That's always an option, right? We call this standard of care. Standard of care means that healthcare professionals, including emergency personnel, are required to do everything possible and reasonable to attempt to save someone's life unless there is a medical order to the contrary. And this again is where POLST comes in. So if you have an emergency, they will do everything they can to save you. But if your POLST form says, DNR, okay, they won't revive you. Or if it says that comfort treatment, they won't take you to the hospital unless they can't make you comfortable in the field. So I'm going to run through some quick examples just to make sure that we're all clear before we move on to the policy stuff. So with standard of care, what I just talked about, the patient has an emergency, EMS shows up, and then they're taken to the hospital. Again, they do everything possible to attempt to save the life, which could mean ending up in the intensive care unit, depending on the emergency. With an advanced directive, if this will still happen, you'll be taken to the hospital and you'll be stabilized. But at this point, the healthcare team will look for your advanced directive, if it can be found and if it exists. And they'll identify your surrogate and try to get in touch with them, ideally in person, maybe by phone. And then together, the surrogate and the healthcare team will figure out from your advanced directive or just your surrogate's knowledge of you, what would you want in this situation? And they'll figure out your care plan. Maybe it's still staying in the ICU, or maybe it's a different level of plan. With POLST, things change again. So patient has an emergency, EMS is called, but this time they look at the POLST form. If it says comfort-focused treatment, meaning they didn't want to go to the hospital, then EMS won't take them to the hospital unless their comfort cannot be managed where they are. For example, the patient has a broken leg. They would take him to the hospital, but everyone would be aware that the patient doesn't want to stay in the hospital and they want to get back to where they were, and the plan will be focused on getting the patient back home or wherever they reside. If, however, it doesn't say comfort-focused treatment, EMS will take the individual to the hospital, and then if the patient had chosen selective treatments, they'll be in the hospital, but again, not the ICU. Or if they wanted full treatment, they could be in the ICU if that's appropriate. So I'm going to pause here just to make sure we're on the same page with what advanced care plans are and that terminology. Does anyone have any questions I can answer? Okay, feel free to ask them in the chat box or at the end.
I have a question.
Moving. Yes.
Where would you put the POLST form? Would you tattoo it on your body, or?
No, please don't. So many people do that. If you want to tattoo anything in Oregon, we have a POLST registry. A couple other states are starting registries. You can tattoo your registry number on your chest. That could be helpful, but otherwise, the POLST form in most states is a brightly colored document, and you're asked to either keep it on your person. So if you're traveling, have it in your handbag, have it in your the glove compartment of your car, or sitting out on the seat. If you're at home, you're encouraged to either put it in your medicine cabinet or most ideally on your fridge. And that's part of the reason that it's brightly colored, is that EMS can look at the fridge and see, oh, pink. Most states use pink, but other states use different colors. And they see a bright pink form, they'll take it and they know that they've got the POLST order set. It's not ideal right now. We are working on some technology pieces. When I talk to EMS folks, they say the other thing, if you don't necessarily want to carry that paper, is to get a bracelet. saying that you've got a POLST form and where you can find it. So for example, you've got a POLST and it's in your purse, and that at least directs them that one, it exists, and two, where they can locate it. Ideally, then you'd have to have your purse near you. I know that that doesn't necessarily help men, unless you do carry around bags. There are some states that also do wallet cards, but that's not something that has been successful. EMS is a little worried about the optics of going through somebody's wallet. They do go through it to try to find ID, but if they have to dig through it for something else, then it doesn't necessarily look great to bystanders who don't necessarily understand that process. So kind of a long answer, but the best thing is to keep it on you to the best you can at all times when you're traveling.
Amy, the 25% that survive to leave the hospital, what proportion of that 25% have no neurological damage?
That is more detail than I know, or I don't know that
It's
level of
about
detail
half
on it, sorry.
some degree of neurological damage. And do you know what proportion of people actually have advanced care directives altogether? It seems to me like it's a very small proportion.
It is a very small, it's about a third of Americans have either like some kind of written documentation or have identified their surrogate.
Thank you.
And what does POLST stand for? I can't remember the acronym.
So nationally, we don't use an acronym. We just say it's portable medical orders. The states all have different variations of it. Depending on your state, most people know it as physician orders for life-sustaining treatment. We don't use that anymore because one, more than physicians can sign the document. Nurse practitioners and physician assistants can sign it, and in Oregon, naturopaths can sign it. So those fields kind of felt left out when we kept using the word physician. And then life-sustaining, people were worried that that was actually showing intent behind the document. And so that was removed. And that's why we just have this acronym of POLST right now, rather than having it spell out anything else.
Amy, I don't know if you can hear me.
Mm-hmm.
Oh, good. Is there any reason not to have multiple copies? One in her car, one in my car, or one at home?
No, and most states allow that, say that copies are valid documents. The only challenge is that if it's not brightly colored, EMS might not find it. But you can always put it like in a pink envelope if your state uses the color pink, and write POLST on it or do something like that. That's not a problem to do. You just need to make sure that you update all of those whenever you get a new version of the document.
Right, thank you.
Mm-hmm.
So that POLST form that you showed on the screen, is
Mm-hmm.
that a document that's used in every state in the United States?
The one I showed is actually the national POLST form that I introduced last September. I'm trying to get all states to use it, but right now only 3 have. So we've got 47 other different versions of the document out there right now.
What about Utah?
Utah has their own version. I think they go by POLST, but yeah.
All right.
It looks, I mean, it still looks similar. It has most of the same content. It just has variations, a little bit of variation in terms of the words and the structure of it, but fundamentally it's the same.
And it has those 3 options for treatment. It seems to me that those 3 options, there is a lack of, if somebody wants to go to the ICU and it's perfectly healthy, I mean, they seem so cut and dry. Anyways.
They are there, and even on the national form, we labeled it as initial treatment. The idea being that if you have this emergency, it's letting people know you had this really in-depth conversation with your provider, and based on your current medical condition, you want X, Y, and Z. So you want to go to the ICU. That's a starting off point. We also have it very clearly on there that is just the start, and they should then be talking to either you as a patient, if you can speak for yourself, or your surrogate, and see, like, does this still make sense? Because maybe your whatever emergency happened was bad enough that the ICU is really no longer aligned with your goals, and you need different kinds of, or different level of care. So you can always void the POLST. Patients can do that on their own, just write void on it. You could get a different one. I mean, it's a starting off point. It doesn't say that this is the care that you're going to be getting indefinitely.
Good answer.
So do you go to your physician to get the POLST form and have him sign it, and then you keep it yourself?
Yes, your healthcare provider will keep a copy of it so that they've got it in their medical record. That's required since it is a medical order. It's just like,
Okay.
they have to keep copies of antibiotics that they've ordered, et cetera. So they'll keep a copy, but they'll give you the original.
Got it.
Okay. All right, so then moving on to the policy stuff. We won't talk too long about policy before I get to research. So the part of Hamilton of interest to us, hopefully you guys have all seen it. If you haven't, I highly recommend it. There's two cabinet battles where Jefferson and Hamilton rap about the differences that defined our first political parties. And in the first battle, Hamilton and Jefferson fight over whether or not to adopt Hamilton's proposal of establishing a national bank. And Hamilton eventually wins with a compromise. In battle two, they fight again, this time whether or not to give aid to France during the beginning of the French Revolution. And Washington sides with Hamilton, so he wins again. What they were fighting about in both of these battles is really what our government was going to look like. Hamilton favored a very strong central government and a single bank for the US, whereas Jefferson wanted more power to the states, and he wanted, he didn't want a single bank. What they were, of course, fighting about is power. Hamilton really wanted the strong central government, and Jefferson wanted just the states to have the most power. We're really debating the same thing in advanced care planning right now. On the left side, you have the national forms, policies, and processes. This is basically non-existent. There's nothing really that's being done at the federal level in terms of advanced directives or these documents. It's really the states that have all of the power here about what's going on. You saw the terminology chart and how each state has all these documents and different names for them. So, and each state under our system of government right now, the legal and regulatory framework for advanced care planning is all about the states. And that means each state gets to establish their own rules about what language is and can be in an advanced directive. For example, in Idaho, you can write down on a napkin what you want. And as long as you've signed it, that is a legal advanced directive in that state. If you were to take that to Oregon, we would have some serious questions about the validity of that document. Because Oregon, like any other state, can decide what we consider an advanced directive in this state. However, the good news is that, well, I didn't put this on there. The good news is that most states have, or excuse me, all states have at least some statute saying something like, if you have some indication of the patient's wishes, you as a healthcare provider are obligated to follow that unless you have a reason to believe that it's false. So again, if that Idaho person was in Oregon, had an accident, but had this napkin saying their wishes, we would at least have to stop and consider whether or not that actually was valid. Now, if it's like a napkin from a bar, we could question whether or not he had the capacity at the time and throw it out. Or we could say that maybe this was serious. It really just depends on a lot of different factors. But the point is that the states can make a determination on how valid and how legal a different state's advanced directive is, which seems a little unfair. Other variations among states are what kind of power a surrogate has. So a surrogate identified by a patient in an advanced directive can have more power than a surrogate designated by law. So for example, in Nevada, a surrogate defined by law, meaning that the patient didn't have an advanced directive, that surrogate defined by law is unable to change a POLST if a patient had one. If the patient has a, if a patient has a POLST saying their DNR, do not attempt resuscitation. The surrogate, if the patient lacks capacity, the surrogate cannot say, we need to change the POLST to CPR, being a more aggressive treatment. They're not allowed to. If they were a surrogate identified through an advanced directive, they would have that power. Again, the surrogates don't even have all the same power in the states. So some states say that a surrogate can't ever make a decision on withdrawing life support. Other states allow for it. Some of them, again, vary. If you're identified in an advanced directive, you have more power than that. But this is all up to the states. And states can decide what a POLST form looks like and whether a POLST form in another state is valid or not. So you can have your POLST in one state and it might not be valid in another. Fortunately, that's not often the case, but this was, I'll give you an example in a second of why this is a problem. Overall, this approach is not great. We've already talked about the ridiculous amount of terminology that is describing the same things. And that makes education and policy a lot harder than it needs to be. It also makes research harder because it's very hard to compare apples to apples when you're using different forms and different terminology. This all kind of worked when we were not really a mobile society. So back when the country was founded, people didn't really travel as much as they do today. But today, people are traveling on vacations pretty easily between states. They're driving their car. They might live in a different state for half the year. They might be staying in different places around the country, or we have a lot more border cities and towns that go over two or more states. And so right now, for those people or patients, we're telling them, please do advanced care planning. But by the way, you might need to have 2 or more forms that you need to track and keep updated. For families and caregivers, you need to help patients track 2 or more different versions of the form. And for our healthcare professionals, we're asking them to understand this ridiculous quagmire on top of providing care and treatments to our patients. So they not only need to be knowledgeable about all the medical stuff, but we're asking them to be knowledgeable about 50 different terms for advanced directives, 50 different terms for POLST, and advise patients on what versions that they need if they're traveling to different states. And I think that's just absolutely ridiculous. So an example of a question I recently received was a patient lived in Vermont, got their primary care at Dartmouth in New Hampshire, and worked in New York. And the question for me was, what POLST form should I use, assuming she was appropriate for POLST? And the answer was she needed 3. Sorry, the New Hampshire one is fuzzy, but look at these 3. They're 3 different names. They're actually 3 different colors because Vermont goes with a green, and they don't look very similar. These are probably the most dynamically opposed different ones that you see out there. New Hampshire's is very similar to most other states, but New York's is very different and Vermont's is very different. So if she wants to make sure that it's going to be followed during an emergency, she needs to have one of each of these, which again, is not an answer I'm happy about giving her. There have been attempts to fix this. One is there's a very general advanced directive document called 5 Wishes. It's usable in 42 states and DC, at least as of 2016. And this is a great one because it provides a lot of area that you can just fill in, and it's really great for just sharing your general wishes. Folks, even in Oregon, you can complete this and just attach it to the Oregon version of the advanced directive. And even though 5 Wishes on its own isn't valid, the information in there will be incredibly useful if you ever need to have your advanced directive looked at for deciding care for you. The second attempt was by the American Bar Association, so the attorneys. They normally try to make things complicated, I know, but in this instance, they were trying to make the simplest document I think you could have. They were only focused, could they have a 1 or 2 page document that literally just said, I want this person to be my surrogate. And they wanted to create that really simple document and have it be valid in all 50 states. And they couldn't, because you see 5 states here that have laws that make it impossible to have a uniform document just saying surrogate, much less advanced directives. And then finally, we have a Uniform Law Commission. They came up with a uniform law where they asked all the states to adopt this exact same law so we could all be on the same page. So 2 issues with that were 1, only 7 states adopted it, and 2, all 7 of those states made edits to it. So it was no longer uniform, which kind of defeats the purpose. Good news is, and I will toot the horn of National POLST here, POLST is unique because there is one organization working with all of the states to try to implement POLST. I work with the state leaders and again, almost every single state, and we define what the POLST form looks like. We're constantly trying to get more consistency and uniformity in education, messaging, et cetera. I mentioned earlier, we have a national POLST form. This is the map showing the 3 states that have adopted it, the 20 states that are considering it, and then the 3 states that are looking to adopt it, they're actively working to adopt it right now. And that's a fair number. If we can get those, that would be awesome. Our goal, of course, is to get all 50 on the same page. But we're unique. Advanced directives, they don't have a similar organization, like one place that's all trying to get all these states together. So we might be successful with POLST, and hopefully that can lead the way for advanced directives, but I don't know. Okay, let's get to the science. I know quite a bit about the POLST stuff. I really dug into advanced care planning for this presentation. And the one thing that struck me is over the last 30 years, And I'm saying 30 years because the Patient Self-Determination Act was passed in 1991. And that was an act really pushing hospitals and healthcare facilities to offer an advance directives to every single person that comes through their doors. So if you ever stay at a hospital, they should either give you an advance directive, it should be sitting at your bedside on your table or something like that. So that it was trying to encourage it. So for 30 years, the research depressingly has stayed somewhat similar and pretty much says a lot of the same things. One definite constant, is mortality rates. So the image is a little cut off, and I know it's old data from the early 90s, but current research does confirm that the mortality rate holds steady at 100%. Given that, we're looking at why people want to talk about it or don't want to talk about it. And in 2014, a California Healthcare Foundation survey found that 18% of people don't want to make any decision about advanced care planning. They don't even want to talk about it. They don't want to have the conversation. Of course, not talking about it is making a decision because they'll receive standard of care, but they don't even want to get that far. And that's fine. Everyone has the right to make decisions about their healthcare. In 2014, the Institute of Medicine published a report called Dying in America, and that said about a quarter of all adults have given little or no thought to their end-of-life wishes. The good news is at least as we look closer to now in 2020, we know that about 80 to 90% of people are aware of it, which is good, and a lot of them think it's important. But only about 10 to 41% have reported either naming a surrogate or completing a written document, which isn't a lot. Again, the data that I saw from 2016 and 2017 is pretty similar. We believe it's important. Having conversations is somewhat or very important. The 2017, 80% of respondents believe doctors should discuss advanced care planning with patients. The corollary to this is that Pew did a research study about 5 years ago, spent a lot of time and money on this, and the one takeaway I remember from it was that patients all thought that if advanced care planning was really that important, that their doctor was going to mention it to them at the right time. All the doctors responded the exact opposite, agreeing that it was important, but saying they didn't want to offend their patients and they didn't want to be perceived as giving up hope or not wanting to focus on some curative treatment. So they weren't going to broach this very sensitive topic in their minds to patients unless the patients asked for it. So absolutely going opposite directions on that. And the end result is that it doesn't matter who, but someone needs to start the conversation. So why don't people do it? Well, it's really because they procrastinate. They always think you can do it tomorrow. It's going to take a lot of time. It really doesn't take a lot of time. The hardest part is thinking who your surrogate is going to be and being able to articulate some of your goals. Topic avoidance. The research is very clear. People do not want to talk about it. So kudos to all of you for being on this call and staying on this call. 3, too young or healthy. There is no such thing. When I was an attorney at OHSU, I was the young one in the office, and I was the one that they were excited to hand a call off to on Friday night when you had a 20-year-old who got into an accident and couldn't speak. Again, in Oregon, if you're over 18, you're an adult, so there's nobody that legally can speak for that 20-year-old unless they did an advance directive. There's not a lot of 20-year-olds that have done advance directives. And sometimes it could get pretty complicated about who could speak for this person if they were in a committed relationship or if they had divorced parents. Like, there's a lot of tension that can be there, especially during an emergency. So these weren't necessarily easy questions. Belief that others already know their wishes. Again, I have a lot of stories here, mostly among spouses or really close-knit families, that they truly believe that everyone's on the same page, and they are just not. Belief that they don't need one, or that it's personal. They don't want to discuss this with anybody else. Providers can sort of help, but what we consistently hear from them is that there's a lack of time at an actual appointment. They're given like 15 minutes and they need to talk about all the medical stuff. And if you're talking about an older population that has more medical problems, you don't really have time to talk about advanced care planning and POLST on top of everything else. Lack of training. We're slowly starting to get into medical schools, but that's taking quite a while, and it's not a required course in a lot of places to have an advanced care planning conversation. Lack of experience. They, again, don't want to be perceived as giving up on curative treatments And oncology is notorious for this. And so oncologists say, I can't mention to my cancer patient anything about advanced directives because I'm worried that they're going to take that as a sign I'm giving up. When in reality, it's supposed to be supportive and helpful. Of course, pushback from families not wanting to talk, and then some also felt discomfort from a lack of personal relationship with the patient. For POLST, there's some interesting studies. This is from 2014. The Journal of the American Geriatric Society published a study showing the strong connection between POLST form orders and where people ultimately die. So they looked at 18,000 death records in Oregon from 2010 and 2011, anyone who had a valid form in the registry and died of natural causes. So what they found was that if you didn't have a POLST form, you had a 34% chance of dying in the hospital. If you did have a POLST form, the rest of it is what happened here. So if it said comfort measures only, that's the terminology in Oregon, again, that meant you didn't want to go to the hospital. The chance of you dying went down to 6.4%. On the other end, if you said full treatment, which was you were fine going to the hospital and you wanted all that treatment, then your odds of dying in the hospital went up 30%. So essentially, the patient gets what they want, and that's pretty effective. There was a follow-up article in 2016 that looked at more recent Oregon data and West Virginia data, because West Virginia has a registry as well, and it essentially showed the same thing. I just didn't have the chart for that to share. And that's good news for POLST, but remember, POLST is our medical orders completed by a healthcare professional with conversation, ideally. Advanced directives doesn't have as rosy of a picture. So again, looking at that 1991 to May 2018, there was an article that came out over the summer that has created a lot of chaos in our field. And the author had said, of 80 systemic reviews of advanced care planning covering over 1,600 studies that have been published, we've got a lot of research on this, sorry, the National Institute of Health and PCORI, which is the Patient Center, oh, I meant to write this down. Anyway, PCORI is very focused on patient-centered research, and they've funded together over 750 research studies, spending 300 million, which for those of you that don't want to figure out the math is about $1 million a year. And there's millions have been poured into advanced care planning, specifically advanced directives by foundations. Sean Morrison was the author of this article, and according to him, there's no strong link between advanced directives and outcomes of importance. I haven't heard any really strong arguments against that statement. Again, 2/3 of adults don't have an advanced directive. He does concede, however, that advanced directives played an important role for nursing home residents with advanced dementia or frail older adults in New York City during COVID. I'm not sure why he's pointing out that specifically, but he at least acknowledges that there can be a role, maybe just in pandemics, I'm not sure. But he made this big, it's a 2-page article that created such chaos in our field. So people took it and they said, well, no, he's wrong to dismiss it so much, because he was essentially saying we should stop funding any advanced directive research. What other researchers said, advanced directives are inherently good. We just don't know what the right outcomes are to measure, or the outcomes aren't measurable. And then there's a huge discussion that's been going on before Morrison's article about whether or not goal concordant care is actually the holy grail of research, and is it actually in our reach? And what goal concordant care is, it's usually defined as care that aligns with the patient's treatments with their goals and preferences. So if you have an advanced directive that says X, Y, and Z, did we actually provide you X, Y, and Z during an emergency? And the reality of this kind of research is that advanced care planning is hard. People change their minds. If you're conscious going into the emergency department, you can say, ignore my advanced directive, ignore my POLST, I want full treatments. And we're going to ignore those documents because you are conscious, you are lucid, you have capacity, so we are going to ignore it. But that might be counted as non-concordant care because you asked for something else. It gets complicated. People are arguing, is goal concordant care really what we're striving for? And how do you even determine it? The last we checked, it's impossible to interview the dead and say, did we provide you the care that you wanted? Was this what you thought you wanted? And the living don't accurately remember, especially in emergency situations. So the research here is, there's a lot of arguments for and against, and a lot of money on the table. I have to mention death panels just because Most people feel this set us back about 10 years. This was talking about the Affordable Care Act. It was about a specific provision of payment to physicians to provide voluntary counseling to Medicare patients about advanced care planning. It's completely false. Several organizations call it out on this. But today, 30% of Americans still believe that that exists in there. And that's problematic for trying to explain in some places about advanced care planning. The good news is that it was put into regulation in 2016. So this payment provision does exist. And if you're a Medicare person, you can go to your doctor and they can be compensated for talking to you about advanced care planning. But that whole death panel discussion actually was probably a good thing because it led to a lot of research on messaging and language. There's been so much work over the last 5 years in particular about what we need, what language we should use in presenting to different patient populations. I'm a part of a group of about 40 organizations taking a 3-year dive to find what messaging we can agree on as a group and ideally use to the public. The other big topic right now is testing conversations. What does a good advanced care planning conversation include? Who should have it? How is the information best conveyed? Is it paper? Is it a conversation? Is it videos? How many times? How often? And how do you test it? And that testing means, what did the patient understand of the doctor? What did the doctor understand from the patient? And then how well did the doctor translate that conversation and any decisions made into chart notes or onto a medical order like a POLST form? There's a lot of opportunity for subjectiveness and testing. Other hot topics, telehealth, COVID, really focused. Can we still have these conversations over phones and Zoom? How do we do that when you can't pick up a lot of the nonverbal cues? And then electronics, there's always interest in registry, implementation, and value. I will end by sharing some resources, just to make sure you're all, my notes, all aware of other things. If you want to have some conversations, bizarrely, there are actually games on this. So gowish.org is actually a good one. You can get the cards, or you can do what I do, which is go online. I do this every year because this is my field. And what you do is I don't know if you see my cursor, but in the top left corner, you can press this button and the card shows up. This card is to be treated the way I want. And you need to drag that card either into the very important row, the somewhat important, or the not important. There's 40 of these cards. And once you're done, you're only allowed to do, for example, 10 very important. It gives a really good snapshot that I attach to my advanced directive. And my experience as being legal counsel in so many patient conferences, this is going to be the most valuable thing I can give for my surrogate and team to say, this is what I care about. Some people, faith things might be very important. Some people, it might be more important to interact and remember who they are. Some people, as long as they can enjoy a sunny day, they're good. We all have different things, and that means different treatment plans. So this is just, I think, a very easy, free tool to be able to use, or just to start the conversation. Compare with your family what you care about. I don't know that my husband loved this, but we're sheltering in place. This is an opportunity to catch up on ER, Grey's Anatomy, and my favorite, House. Take time, just pause in the middle of one of these, turn to whoever you're watching it with, and just say, what would you do for me if I was that person, that patient? And it can lead to some pretty interesting conversations. I know that Jake and I, we did this years ago, and while we agree a lot, we actually both have very different ideas of what makes for good quality of life if we're not aware of who we are at the end of the day. The Conversation Project, this is a great group. They have starter kits that really help you start that conversation. The first words are always the hardest, so they have a lot of resources that you can use. If you just want to figure out your advanced directive or start thinking about who your surrogate might be, Prepare for Your Care has some really good, very easy step-by-step things of how to think about what you care about or who you should choose. And then National Healthcare Decisions Day is always April 16th. April 15th is taxes, April 16th is death. It's really just, we're focusing on National Healthcare Decisions Day. That's how we remember it. And a lot of organizations are really trying to focus and remind people this is a day to think about and share their wishes. So if nothing else, again, please remember, identify your surrogate, put it in writing, share with your surrogate. 2, advanced care planning can make a difference in your care. No guarantees, but you can be thoughtful about how you're sharing this kind of stuff. And 3, state laws, terminology, requirements, and documents vary. So it's very easy to be talking about the same things, but using different terminology with people, including care professionals if you're in a different state. So feel free to email me if I don't answer any questions, what your question tonight, or something comes up after today. I'm always happy to take questions. You can email me at amy@polst.org. And then again, I put in the chat box all the links that I just mentioned. I will paste them again in case you joined later. So you can take a look at those. And that is it. Can I answer questions?
Actually, I have a comment.
Sure.
I'm a retired nurse, and in my career, I worked ICU, CCU, the emergency room, and the issue came up constantly. What to do for this patient, especially when they crash, because I was an intensive care nurse. And I can remember having to go find the chart and drag it down and show the page that said DNR before the doctors would leave the patient alone. And this was before all the kinds of things you're talking about with POLST and even advanced directives. This was strictly written by a doctor because the patient said to them, I do not want any special care done. And this happened frequently. So it's important people realize that if you don't have the documents and it's not in writing, they're going to do everything because that's what their job is.
Thank you. And unfortunately, that still can happen today. And
Yes.
that is all the more reason to have that surrogate that is going to push, just like you did as a nurse, and say, no, my mom or my dad or my sister didn't want this. They said DNR. We are also a very litigious society. And one thing that has been shifting over the last few years is previously, and it's still on this end, that we are being very conservative, figuring that a patient dies and that's final. So we're going to do everything to keep them alive unless we're absolutely sure that the patient didn't want that treatment or was DNR. And there were a lot of kind of lawsuits about that. It's shifting, and I don't like that it's the law that's making this happen, but there are shifts now to have wrongful life suits where patients are suing and saying, look, I had a DNR, I had a POLST that said DNR, you still resuscitated me against my wishes. And so they're suing facilities for it. The good news out of that is that facilities are starting to pay more attention to these documents and saying we actually do need to follow them, but we're still in this area of gray. And so having that surrogate to say this is absolutely what they wanted is, again, the best thing that you can do for yourself.
I'm surprised you haven't asked this group how many of us have advanced directive surrogates and POLST forms.
You know, I asked Bruce if I could do some polls because I would have loved to, like, I didn't want to put anyone on the spot in doing the group chat, but I wanted to do an anonymous poll and that just wasn't possible. But yeah, if everyone has one, then we're good.
I think we should all POLST shame Bruce. I do have an advanced directive. I do have a surrogate. I do have a POLST because my wife is a physical therapist. But thank you for your presentation because I now realize that it's absolutely worthless sitting in my file cabinet under legal documents where maybe somebody after a week of looking could find it. So thank you.
Sure.
Well, I'll tell you, I don't think we have a POLST. We do have advanced directive, but it's squirreled away. So we're gonna work on that.
Okay, so we're gonna shame you. Shaming Bruce right now.
Well, and remember, for POLST, it's really for people who are seriously ill or frail. Assuming you're healthy, you want full, it'll say CPR and full treatments, and that's standard of care anyway. So there's no need for it, and you don't want to create that surrogate burden. So if you have a POLST, that's fine, but you probably don't need it until, again, you have a serious illness or you have advanced frailty.
I don't know. Bruce is looking pretty frail there.
Yeah.
So Amy, this is Alan in Colorado.
Hi.
And our local hospital has been really good, or at least in doing outreach and encouraging us to sign forms, doing advanced directories. And so we're most, do a most form. But what I think I hear you saying is that if I don't have a separate DNR form available for an EMT, I'm going to the hospital.
No, the POLST form is a DNR in Colorado. Some states it varies, but the idea is that a DNR really just says one thing, which is do not resuscitate. And that is only helpful if you're talking about needing cardiopulmonary resuscitation. What POLST does, and why most for Colorado would be different, is that one, you can say DNR, but it also allows you to affirm that you actually want CPR, if that in fact is your choice. And then two, if you don't have, if CPR is not a question, you're breathing, you've got a pulse, but you still have that medical emergency, if you have a DNR, that means nothing to EMS. They have no idea of what your wishes are beyond that. Whereas if you have a POLST, it then tells them, oh, you want to be made comfortable where you are, we're not supposed to take you to the hospital. Or you want to go to the hospital and you want these different things. What some research that came out of Indiana and even Wisconsin a few years ago, and what we're trying really hard nationally to clarify, is there's also an assumption if you just have a DNR order, that's equated to do not treat in the healthcare field. And there's research that shows if you have DNR and you don't have a POLST form, it just says DNR, you get fewer aggressive treatments than if you have a POLST form that says DNR and then selective treatments or full treatments. For some reason, there's just this equation of DNR is always comfort, and that's not what about half of the people that we see in Oregon's registry, that's not what they want. And so having that form that clarifies DNR, but this is the next level is really helpful.
The other thing is, which we've had to deal with, is DNR versus DNI. Do not resuscitate versus do not intubate. And there are many people that feel very strongly, all right, try CPR, but do not put a tube down me. And that has to be spelled out very carefully.
Yeah, and you'll, at least on POLST forms, because they're out of hospital order sets, we don't really offer that. If you get CPR, at least on the national form and most state forms, it'll also say that you're going to get intubated, because in the field, that's protocol. But if you're in the hospital, it's entirely possible for you not to be intubated. I mean, it depends on obviously the medical condition, but that's a big discussion we've had among our providers over the years.
We were just,
Me, I have a question.
we were filling out our POLST forms, and they're actually, at least in the one in Utah, there's a comment section. So you can say you want full treatment or you want whatever level you want, but you can also put in the comments more specifics of what you want. So for example, the intubation piece, you can put that on your POLST form for us, at least.
You can, sorry, I didn't mean to jump in. You can do that. Every single state has another box that's either comments or additional orders, but what you want to be aware of is that that may not happen. EMS does not look at that section. So if their protocol says you're in the field, you have CPR, or you have a heart attack and you want CPR, their protocol is that they are going to provide CPR, intubate, and take you to the hospital. They're not going to look at that section. And if it says do not intubate and that's against their protocol, they're still going to ignore it because they're following their protocol for the CPR, which is the more critical piece first.
Well, that's good to know. Thank you for pointing that out.
Yeah, that was something I actually learned through the process of creating the national form. EMS, like it was just, I can't believe it hadn't come up in the previous like 15 years. They're like, yeah, we don't, I mean, we might look at it, but you know, we might not be able to pay attention, like we literally might not be able to follow it because they're so protocol driven. So on the national form, we actually have clarification over that comment section indicating that EMS may not be able to follow that because of their requirement to protocol.
Good info.
You just said, Amy, that most people, especially younger people, don't really need the POLST form.
Right.
But
Want it, yeah.
if you don't have one and something happens, you get hit by a car or you get a sudden disease or something, you may be in no condition to get a POLST form then. So
that's what your surrogate is good for. So if you're young, you're 20, if you have an advanced directive that says this is my surrogate and these are my wishes, even if you just have it filled out to say this is my surrogate, you get hit by a car, you're going to get our standard of care. because assuming you're 20, you want to live, they're going to do full treatment, they're going to provide CPR, and they're going to do everything reasonably possible to attempt to save your life. So they're going to transport you to the hospital. And at that point, that's when they're going to be looking at the advance directive, the surrogate. And if it's a really bad situation, that's when you can have a conversation. And again, in most states, the surrogate is going to be able to work with the physician to complete a POLST if it's then needed for that individual patient.
What
Okay,
about
thank you.
minor children? Are their parents automatically the decision makers for young children?
Yes, they are. Most states is 18 or younger. Oregon, bizarrely, it's 15 or younger. But yes, they're able to make decisions. And most states, there are, I think, 3 that don't allow it. Most states will allow parents to complete a POLST form for their, or to sign a POLST form for their child. States like, there's someone on from Colorado. Colorado is one of the states that doesn't allow a POLST form there to be completed for anyone under 18.
Would it be legal guardian in place of parent if, you know, the parent doesn't have control of the child?
Yeah, if you're talking about anyone under 18, you would look first to the parents. If they don't have legal authority, the legal guardian, or sometimes you have an emancipated minor. And so that would be the order that you would look in for authority.
I think the thing that's hard for most people to understand is that these decisions get made in a crunch. So the doctor often doesn't have the form in front of him, and he's frankly not going to defer to the form unless he has it in front of him. The family may not be available. The doctor may not be someone, almost likely is not going to be someone who knows the patient long term. The situation is ambiguous, meaning that the doctor really can't predict what the outcome's going to be. You know, if a person has a cardiac arrest, how long do you work on them before you give up? And we have some numbers that tell us the likelihood of return without neurological disease, but the numbers are not totally predictive. It's not a one-to-one relationship. Some people survive a little longer with relatively little neurological disease. Some people show neurological damage pretty quickly, that sort of thing. Another issue is that the families are often confused by the whole process. So if you've got families that are fighting with one another about what the decision is, the doctor will always treat. And the reason he'll always treat is he's a lot less likely to get sued. And so until the family has decided among itself, you know, this is the path we want to take, typically the doctor's bias will always be to treat in any ambiguous situation. And I think what's hard for many people to understand is those of us who are of an age and have various chronic medical ailments often already have some degree of cognitive impairment. And it's often unappreciated by the doctor as well as the family. So whether we should be participating in decisions or not is hard. I spent a lot of time in my career trying to decide whether people were competent or not. And I began to be convinced that probably most of us are not. Probably we're not from about age 18 on.
I agree.
No, I mean, that's important what you were saying. Like, a lot of this isn't a crunch. We always, at least here, we're talking about the estranged daughter flying in from New York. So you have to keep mom alive so the daughter can say goodbye and resolve issues, or, you know, vice versa. And that's not necessarily what the patient wanted. So having the surrogate being a strong advocate is kind of important. But the other thing too, I love the story. One of my nurse colleagues told me this years ago. To encourage conversation among the family, she and her husband decided that they were going to rent a beach house out in Oregon on the coast for Thanksgiving weekend. And she invited the entire family, so her parents, all of her siblings, and all of their kids. And it was a really great day on the beach. They had their dinner, and then after dinner, the kids went to bed, and all the adults went around the table. They brought out a case of wine, put it on the table, and then she gave everybody a copy of an advance directive. And she said, all right, we're not leaving until everybody has this finished and we know what each other wants. And she said the conversation went really late. but they realized that they thought they were on the same page and they actually weren't on a bunch of different things. But at the end, they were all very clear about what each other wanted. And of course, unfortunately, about 6 months later, their dad had a heart attack. But when they got to the hospital, she said the sense of peace that they had in all being on the same page was invaluable. And she said this could have been a chaotic time where they had the argument that they had over wine, 6 months prior, but instead they were all really supportive and on the same page with exactly what their dad wanted. And so none of them had any of this burden afterwards because they knew. And I appreciate that that's a really hard thing to do. But that story always makes me feel like that would be a real gift to be able to give to your family members. Just one night, awkward conversation, pull out wine, make it good wine, make it a memorable thing where it goes,
Hey, I live in Oregon and work in California, so I'm like one of your examples there. I'm realizing I need a POLST for California. Do I also need to have a separate surrogate designation document for California?
So I would say one, I still think you might be too healthy for a POLST, but the good news is that between California and Oregon, those forms are so similar that the states recognize each other's version of the form.
Oh, okay.
So if you've got the Oregon one, you should be fine in California and vice versa. I think the bigger issue is that Oregon has, Oregon's advanced directive, I think would be honored in California. California's might not be up here. That would be the document that I would try to make sure I had two of, just to be sure that you've got it covered, or at least talk to somebody who's knowledgeable.
Say again, which one should I have two of?
The advanced directive.
Okay.
I would we'll talk to an attorney that might be able, or maybe an attorney or somebody that can speak to both state laws. I don't know that off the top of my head.
Okay, thanks.
You might want to make contact with the AARP. You can download advanced directive forms for each state from the AARP. And I don't know if they're on board with the POLST idea or not, but
They support us.
They're an important group for those of us of an age. All of us hear from them regularly, and they can be helpful in communicating.
Yeah, I was saying the only reason to contact an attorney is to see if a second one is needed. If we know that California would accept Oregon's version of the advanced directive, you don't need to go through that work. But if it's easy to do the second one, it doesn't hurt.
All right. Well, this has been really good. It's nice to hear from somebody that really knows what she's talking about. So.
As opposed to all previous speakers.
Yeah.
With that, I will introduce John Miller, who's going to talk about
Speaking of which,
extraterrestrials next week. John, are you still there?
Don't see him.
he had a heart attack during the presentation and they're still looking for his POLST.
I think he's been uploaded into the spaceship. So next week, John Miller is going to be talking about extraterrestrials for the second time. I think maybe after they found
yeah,
Mars.
I'll be, it's kind of a repeat of one of our first talks in April. I will update it. There's been some interesting analysis of stuff of organics in Venus's atmosphere. And also, I didn't talk about the alcohol cloud. So let me talk about that as well.
Okay.
Okay.
The alcohol cloud that is swirling about your head. Yeah. Okay. Can't wait.
No, it's 11,000 light years away, and nobody knows what created it because stars do not create alcohol. Alcohol is an organic material.
Hey, Bruce, I got a quick question. In an earlier session, I thought I heard that somebody was going to be teaching a 5-6 week course on artificial intelligence. Was there?
Yeah, I've been taking it. It's
Artificial intelligence.
Yeah.
Oh.
Yeah, Peter Scott.
So where do we get tuned into that?
Well, it's $100, and you go to University of Victoria.
Okay, University of Victoria. Okay.
University of Victoria.
Okay.
Peter Scott.
Okay.
Okay.
Thank you.
I need some artificial intelligence.
Well, thank you, Amy.
All right, that was really good. That was a really
Yes.
good talk, Amy. Thank you very much. Let's give her a round of applause, everybody. Yay. Thank
Not
you.
here. I don't see her.
Thank
See you
you.
next week.
Okay, take care.
Thank you.
All right.